Welcome back, Dave. I hope you had a great break.
It's been a break.
Yeah. So that last video, 9,000 views, incredible. And something I got from the comment is that people don't understand when we're joking or not. So just some housekeeping. We're not really sponsored by Tap Water. It's a fictional sponsor, and both of us shower regularly. And despite the fact that you're wearing a tank top, which a lot of people refer to as a wife beater in the comments, you were in
Politically
actual work.
incorrect. The tank top. Well, we uh we had no idea how many people would actually view that last episode. For our first three, what we have like
100
dozens.
to
It's
200.
pretty much our Facebook friends and family and stuff like that. But I should add in that I wouldn't have dressed any differently. Like,
That's
got
true. And I told you, and I think you thought I was kidding. I said I was going to wear a collar shirt just to shame you into work, putting on a normal shirt.
which
And
would not have worked.
yeah, it didn't work. And so what we've learned about you, Dave, is that you have no shame.
Oh, I'm shameless.
Yeah.
Well,
So
I was referred to as the worst dressed guy in the law school. Uh, I think I did mention to you the clerkship story. Here I had to wear a suit every day for the clerkship. My judge, he was old school. He had been a JAG in World War II. He was 92 years old when I clerked for him. So, we were wearing suits. In fact, he had previous clerks help him with something with a boat, and he told them to wear old clothes. And he ended up, his version of old clothes was an old suit and like walking into water in a suit. So there was one Saturday where he was supposed to be visiting his relatives, and I went into the courthouse to do work. And it's a Saturday, so no one's going to be there. He wasn't going to be there. He was supposed to be out of town. So I went there in sweatpants and a t-shirt, which is my usual attire if I'm not in a tank top. And he ended up coming in because he canceled his plans. And then he ran into me, and I thought this man was going to have a heart attack. His response is, David, he was shocked and horrified. I apologized. I said, Judge, I didn't think you were going to be here. We called him Judge. So yeah, and actually, when I went to Debevoise, one of the big reasons I went there was because at the time, this was the turn of the century. The white shoe law firms, a lot of them were still mostly suits, like casual Friday would be called. So Debevoise was business casual all year round. It's like awesome. So yeah, short story is I uh, I dress down. That's the way I dress.
all right, this is just normal for you.
It is very very normal, as everybody knows. My classmates knew. Everyone knows.
So we got some really great comments on the video and some really great questions, and we try to respond to them in the comments, but some of them take a lot more explanation. So we thought we'd do a separate video, and we're going to answer specific questions about Wisconsin appeals and that particular case and things like that. So those of you that asked for that, you're going to get in spades. And I really wanted to do this. I just came back from Florida. I think I told Dave. I came back. There was a flood in my basement. My flight was late, but I made it here. And
Southwest
while I was in
Airlines.
Florida, there was a
You're on
cold
Southwest.
spell. No, no, it wasn't Southwest.
Okay.
But when we were in Florida, there was a cold wave, and frozen iguanas were falling out of the trees, and there was like a 3 foot one next to my car. But I still made it here. So literal flying lizards, frozen, dropping from the sky, didn't stop me from being here. We're gonna do
Plague.
this. We're gonna answer everyone's questions right now.
You went through a plague.
Exactly, plague, like not locusts, frozen flying giant iguanas. But
Magnolia, the movie
yeah.
Magnolia.
So I'd like to start with the appeals process first, but before we start, uh, let's do a piece of legal trivia, and then we can. This will be a
Okay.
new thing. And I have a question, and there's two possible answers, and I've written one here, which I know you're going to answer. But if you've seen in the UK, they wear these wigs and robes, and so do the lawyers, and we don't do it here. And there's two answers that I'll accept. But what is your reason why you think we don't,
My
as
my
lawyers, wear the wigs and the robes. And
my rationale for it, because it's fucking stupid.
okay, that's one answer. And I actually wrote it on a post-it here because I thought that that's what you'd say. Stupid, idiotic, ridiculous. But and the actual answer is that it is stupid. And when we broke off from England, there was a debate about, should we wear the silly hats, and the two people who decided this were John Adams, who wanted everyone to wear the silly wigs and the robes, lawyers and judges, and Thomas Jefferson, who thought, no, this is ridiculous. Like, why would we ever do this? And the compromise they came to was, okay, we'll have the judges wear a robe but no wig, and the lawyers don't have to wear anything. Because Jefferson said, no, we should just wear suits. And John Adams, who was very old, said, no, we should accept everything. But
What do judges wear under the robes? That's the next bit of trivia.
I don't know. Maybe it's like the Scotland people with their kilts. They wear nothing. Given the age of judges, I don't know, and I don't want to find out.
Yeah, I don't want to consider that too much.
Yeah. So let's start with the appeal. So people had some very specific questions about the appeals. Why is he appealing? Why does he get a lawyer for this? Is there a chance that he'll get a new trial? So let me just go over generally what happens in Wisconsin. And I should say that neither of us is admitted to practice in Wisconsin, and this isn't legal advice. So, if you need legal advice, you should seek competent legal representation. So Dave is very competent, but he's not licensed anymore. So, he's competent, but he's not a professional. I still have a license, so I'm a professional, but I'm not competent. So, seek competent legal guidance if you need help with this, and that's not us. We'll talk about this case, though. So in Wisconsin, basically, whether you're going to appeal or not, you should say you're going to appeal, because in Wisconsin, you have 20 days to let them know you're going to appeal. And then if you don't say within 20 days that you're going to appeal, you lose the right to all your state appeals. So you always have a right of federal appeals, but you lose your state appeals if you don't file within 20 days. And that's why as soon as the sentence was passed, the clock starts ticking, and he said, I would like to appeal, and give me a real lawyer this time. I'm not going to do it myself. So Wisconsin, 20 days. Now he has the right of appeal. And things about the appeal process that people might not know, you can only talk about what was in the case in the appeal. You can't introduce any new evidence, only what was in the case. And the reason that you would need a lawyer for this, or it would be really helpful, is that the things you have to file, the briefs, have a very specific format with cases cited and the order they go and how. So you have to follow that. Otherwise, your appeal goes nowhere. And I know that he was very disruptive during trial, and that annoyed everyone, including me. I didn't like to watch the trial. I preferred to watch the recaps where they edited out most of his nonsense. But in an appeal, he's got the intermediate appeal, then he's got the appeal to the Wisconsin Supreme Court, which the trial judge is now running for that. And the thing to know is that you don't get oral arguments as a right in an appeal in Wisconsin and most other states. They could say, yeah, we'll allow you to argue in front of us, but they don't have to. They can just take your motions and say, no, the appeal is denied. And that's probably what's going to happen here, especially considering the fact that one of the commenters in the last videos, his name was Martin, and I think he's a friend of yours. He's a lawyer from Wisconsin, said, look, these judges, the trial judge, the appellate judge, even the Wisconsin Supreme Court judge, they're all elected. So what judge in their right mind, after seeing this guy do what he did to those 70 people, 6 of them died, including a child who was, dragged to death, and a bunch of old ladies who were dancing grandmas got run over, and, kids in marching band. What Wisconsin judge who is reliant on the voters to keep him in that office would give this guy an appeal? But we will discuss this as if there were legal issues that they would consider even if they weren't elected. And but that's the basic. We don't think he would get a state appeal, and then the federal appeal is always there. And if you didn't file your Wisconsin appeal, you have 20 days. You would lose all your state appeals, and then you can go directly to the federal. But again, it's very hard to get a federal appeal heard from a state conviction. I read somewhere it was less than 3% ever get get considered by the federal courts. So you're better off trying to get heard in the state court, but it's not likely to happen. So I'm not an appellate lawyer, but how did I do? Is that correct?
It sounds good. I did think we should, and I think I was remiss in not mentioning this in the last one. Typically speaking, you can't just scour a record looking for issues. It's got to be preserved at the trial level, which is also why you'd want to have a lawyer there preserving these issues for appeal. I mean, it's a basic issue of fairness. You want to allow the trial court the ability to correct errors, and you don't want surprises in the appellate level either. So you need to object on the record typically and have a response from the judge for an issue to be appealed. I mean, there are some exceptions. I think, like, if the court assumes jurisdiction it didn't have, I think an appellate court will say you couldn't have done that. But generally speaking, if you're finding errors or what you perceive as errors, you need to preserve it on the record so it's there, and then you can bring it up on appeal.
Right. And jurisdiction isn't what Darrell Brooks thought jurisdiction was, where if I don't consent, you can't do this to me. That's not what jurisdiction is. Jurisdiction is, for example, state lines or something like that. So, and
which there are actually like two types of jurisdiction to make. There's subject matter jurisdiction and then personal jurisdiction. I think Brooks was just talking about personal jurisdiction. Subject matter jurisdiction is it's a real big one, because if the court doesn't have power, subject matter jurisdiction is the power to hear what's being, like, if something takes place in New Jersey and you try to bring a lawsuit in California, they don't have subject matter jurisdiction over that. Nor do they're probably not going to have personal jurisdiction either. But, so if a court there somehow listens to a case it doesn't have power to hear, and then it's on appeal and it wasn't even brought up at the trial level, it will be reversed. But there are those two distinct types of jurisdiction that lawyers have to think about: the subject matter and the personal.
Right. And personal jurisdiction is almost never an issue in a criminal case, because the fact that you're sitting there in an orange jumpsuit in handcuffs, and then the judge can say, take him out, bring him back, that shows she has personal jurisdiction over you. Subject matter jurisdiction, it's also really rare. And in law school, law professors are known for these really weird hypotheticals. So, if somebody is murdered on the border between Illinois and Missouri, can both states try him for murder, things like that. But, sometimes that is an issue. So there was recently a Supreme Court case, I think it was last year, where somebody was arrested for murder. And in Oklahoma, there's this really weird system where if you're on an Indian reservation and somebody who's a Native American sells it to somebody who's not Native American, that is no longer Indian land. And there was a murder committed. And because you have this kind of checkerboard all over the state of, this is reservation, this isn't, this isn't. And they weren't sure where this person was murdered. They knew where they found the body because he moved the body after, but they weren't really sure where the person was murdered. The question was, was this an Oklahoma case or was this a federal case? And that actually went all the way to the Supreme Court. So really interesting issue. But again, it was pretty clear this was in Waukesha, Wisconsin. So the state had jurisdiction over this, personal and subject matter jurisdiction. And subject matter jurisdiction, as you said, it's very rare that would come up, except in certain instances, like you're doing something in a state where you're taking an action in your state against another state, or you're hearing something in a bankruptcy court that should be heard in the district court, something like that. But we should say that if he has no appealable issues, he's going to get a lawyer. But the lawyer under Wisconsin law, they do something called give him a no merit letter. Which says, I don't think you have any issues that I can appeal. Have a nice day. And then he has a chance to respond to that. But, if the issues that he wants to raise on appeal are these sovereign citizen arguments that, I didn't consent to this, and I'm a corporate entity, and, you in the charging documents, you wrote my name in all capitals, and that's not my name. If that's the arguments he wants to make, the lawyer won't make those arguments because they're not arguments that have merit. And as a person who's a member of the bar, you're not allowed to submit these things to the court because you're an officer of the court. So, he can submit this letter saying, I can't argue what he wants me to argue. There's no merit to this. And then he can do it on himself, or he can kindly say, okay, these are the issues that I think you have, and draft an appeal for him, and then give it to him, and then have him add his own wacky sovereign citizen stuff, and then submit the whole thing under his own name, not the attorney's name, because the attorney would never say, I'm going to submit this under my name, arguing, these frivolous things, dealing with capital letters and the flag that has fringe on it, so it's a maritime. Like, no lawyer would do that, because you're a member of the bar and you're an officer of the court, and you have a duty.
Well, it's unethical. You can
right.
get disbarred for making frivolous arguments.
Yeah. So
should also point out he is entitled to a lawyer on his appeal of right, his first appeal. The U.S. Supreme Court extended that not only to trial courts, but also to your first appeal. So he is entitled to a public defender, as any criminal defendant would be under the U.S. Constitution. And I think also, just related to the oral argument aspect, you should also make clear, I think lawyers know this, but lay people may not, that an oral argument is also, you're confined to the arguments you've made. It's not like you're going to make something that, a new argument that they haven't seen yet. So generally speaking, oral arguments don't win cases. I think the maxim is you can't win a case with oral argument, but you can't lose one. Like if you blow it, because judges will start they try to ask, even if you have a judge that's on your side, they'll ask you questions, and they try to maybe even lead you to the correct answer, or what should be the correct answer. And sometimes lawyers don't actually follow that path, and you can blow a case that way.
Well, one of the things that's interesting, and as we said, representing yourself as a defendant is a terrible, terrible idea. But he made a lot of objections and repeatedly made the same objections over and over, and the judge threw them out. But if you're objecting to the wrong things, or you're making an incorrect objection, that's on the record. But that wouldn't be appealable if you hadn't made if you were objecting to the wrong thing. So if you said objection relevance, and she let it in, something like with his criminal conviction, it is relevant. But if he said objection, it's prejudicial, then that would be preserved, and that's an appealable issue if she overturns it. But if he says, because he kept objecting relevance, and sure, it is relevant, but if you're making an incorrect objection, you can't argue in your appeal that it was prejudicial to me, because you didn't object that it was prejudicial. You objected that it was relevant. So he screwed himself that way. And also, he seemed to be trying out different strategies and see what would stick. And there was one which I don't think would have worked, because there's testimony that he was intentionally hitting people. But I believe a mechanic testified that the car was in perfect working order, the brakes worked, and he tried to ask the guy about a recall on that model car. And if he had a defense attorney, the proper way to introduce that would be to have an expert witness come in and say, these cars have this issue, and it's been recalled in the past, and and then you would preserve that for appeal. But he didn't introduce that into evidence, so now he can't raise that on appeal and say, well, maybe this car was defective and I lost control over it, because you never introduced evidence that was the case. And so now you've lost that on appeal. And and we did talk about the ineffective assistance of counsel. If you represent yourself, that's one of the most common ways to overturn a case and get a new trial, is that your lawyer was terrible. But if you represent yourself, no matter how terrible you are, you don't get a new case. Just getting back to this, the appeal thing. I think I mentioned if you don't have any appealable issues, the attorney can say, I can't help you out here. And that was a famous Supreme Court case also, where I wrote it down here. I'm not that smart. McCaskill versus Wiggins, where the guy was arrested for possession of marijuana, and he didn't. He wanted an appeal, and maybe that's not the case. But yeah, the lawyer basically said, "There's nothing you can appeal," and he didn't get him. He didn't want to represent him, because all his appeals were frivolous, and the court said, "Yeah, that's fine. You don't have to make frivolous arguments just because you're a lawyer. You can tell him he's got nothing he can appeal." And you do have, I think you mentioned, as a matter of right, a lawyer for your first appeal, and that was this case, Garza versus Illinois, which actually went to the Supreme Court because the person was not given an appeal. Well, I think he had waived his appeal, and he tried to argue that it wasn't knowing, but they said, no, you waived your appeal. But you've always got that right to appeal. And this went all the way to Supreme Court. And this is a scary case because the court said, yeah, you do have a right to an attorney on appeal. But three of the justices dissented that are on the bench now. It was Gorsuch, Clarence Thomas, and your favorite, Alito. And two of them, Clarence Thomas and Gorsuch, said that
There's
not only do we
an
think
audio.
that,
You're having a bit of an audio issue at times. Just to
okay,
it's
sorry about that. I'll pull this out.
better.
So two of the people, Clarence Thomas and Gorsuch, said that not only do we disagree that you're entitled to a lawyer on appeal, but we think you're not even supposed to have a lawyer appointed to you and paid for the state for trial. So they disagreed with Gideon versus Wainwright, two of the three dissenters. Yeah, that's scary that you can be arrested and two of the sitting Supreme Court justices think that you're not entitled to a lawyer if you can't afford one. And 80 to 90% of criminal defendants can't afford a lawyer in their appointed counsel. So this would be very scary if the majority of the court thought that way. Well, before we get off the appeals, let me just mention one thing about that Gideon versus Wainwright case. So it's actually a famous case, and they turned it into a book, Gideon's Trumpet, and they turned it into a movie. Henry Fonda was in it. And not me or you, because we're a lot younger than that. But I mean, you probably had a professor or two who said that, like, oh yeah, I read that book and it inspired me to be a lawyer. So Gideon versus Wainwright, it was a case, a guy was, this petty criminal, and he was arrested in Florida, and they told him he wouldn't get an attorney because at that time in Florida, you only got an attorney for capital cases, if you're facing the death penalty. And he appealed to the Florida Supreme Court, got nowhere, wrote a 5-page handwritten brief to the Supreme Court on prison stationery by hand and submitted it. And then they decided to hear the case. Famous case, Abe Fortas, who later became a Supreme Court justice, was appointed to argue the case. And one of the Supreme Court justices said that this is the best argument before us I've ever heard in my life. And then they gave the guy a new trial, and then they implemented this thing where indigent defendants get counsel. And it does matter if you get a lawyer or not, because he was convicted the first time. On the retrial where he had a lawyer, he was acquitted. And interesting thing, the argument that Abe Fortas told the Supreme Court that, they found so convincing was Clarence Darrow, who was considered the best litigator in the United States, the Tiger Woods of litigation. When he was arrested for something, he was arrested for jury tampering, he hired his own lawyer because he didn't want to represent himself. So if even the best litigator in the entire country says, it'd be crazy for me to represent myself in a trial, then what chance did this guy Gideon, who was this petty criminal who was not familiar with courts, what chance did he have? So,
well, hopefully it will remain good law. I am not overly concerned that that's going to turn into a majority.
Sorry, I couldn't hear you when I plugged this, but
I just said hopefully it'll remain good law, but I'm not overly concerned that the 2 will become 5.
Okay, so that was my rant. You had this epic rant last time, so I think I'm entitled to one epic rant.
It's a good rant.
All right, thank you.
Yeah, it's a significant thing, and it is concerning that you have 2 justices now that would say, oh, if you're indigent and the state has all its weapons that it can use against you, and you're not entitled to anything. That's when you think about the odds there. It's
right. Oh, one other thing about the appeals process before we go. So people might be asking, well, why do you only get 20 days? What does it matter? So now we have everything videotaped, but generally that's not the case. And you have a court reporter typing. And then if you do want an appeal, then they would type that up. And then that's a record of the case. And then, if you want to say, I made this objection here and it was overruled, then you would say, page 450, line 28. That's the official record. So if you don't file an appeal, they wouldn't prepare that because, it would be ridiculous to prepare it for every case, especially when somebody pleads guilty. 90% of the cases don't ever go to trial. People plead. And so why would you prepare transcripts of all this? It would be incredibly expensive. So you'd have to let the court know that I'm planning on appealing so that they would prepare that. And so, 5 years down the road, if you said, you know what, I think I would like an appeal now, and they don't have that transcript, then you can say all kinds of things like, hey, I was treated very unfairly in this trial, and there's no proof that it did or didn't happen. So the way to get around that, just as a society, is if you want to appeal, you got to let us know. And there's plenty of reasons that people wouldn't appeal. If you got a decent sentence and you appeal and you get a new trial, let's say that the range of punishments is 5 to 15 years and you got 8 years, and you say, you know what, I want a new trial, and you get a new trial because they made some error, the next judge can say, you know what, 15 years. And then, you have no options. So there's plenty of reasons people wouldn't appeal. But, if you do want to appeal, you've got 20 days in Wisconsin to do that. So that's all I wanted to say on appeal. And I did want to answer some specific questions in the comments that we had an interesting time discussing about jury nullification and things like that. So you're somebody who has very strong political beliefs. So this would come in sometimes in people who are prosecuted for things that are politically unpopular, like possession of marijuana or political protesters or things like that. But you know what? I should give people a warning. If you ever want to serve on a jury, skip forward about 10 minutes now, because what we're about to say may get you disqualified from jury duty on any important case. So don't listen for the next 10 minutes if you ever want to serve on a jury.
Or listen and don't actually express it in
Right.
any way that will get you excluded, unless you don't want to serve. I mean, there are people who will say things so they won't get, they'll be at voir dire and then we'll say, "Oh, I just hate everybody."
Yeah. If you say you hate everyone, as long as you hate everyone equally, then that's
I
not
hate
biased.
everybody equally.
Yeah, you get it. But
I don't like people with long hair.
So the reason I said skip ahead if you ever want to serve on a jury, the way to think about jury nullification, it's like Fight Club. And what's the rule about Fight Club? You don't talk about Fight Club. So jury nullification is actually a thing, but you're not allowed to talk about it. You're not allowed to argue it in front of a jury. And actually in Michigan recently, somebody was arrested for handing out pamphlets in front of the courthouse, just telling people about jury nullification. Like it wasn't even regarding a specific case. They arrested this guy because he was handing out pamphlets in front of the courthouse, and they arrested him for jury tampering. And the only reason he got off was that none of the people who got the flyers ended up serving on a jury. But if some juror had gotten that flyer, that conviction might stand. But so jury nullification is basically you can disregard the law. And the way that go ahead.
I think we should be more specific about when. Like, in a criminal case, when you disregard the law, you let a defendant go and it can't be appealed. I mean,
right.
That's your jury nullification. Because if you disregard the law in a civil trial, it's going to get reversed. I mean, that's, so jury nullification in a civil case is ultimately going to get reversed by an appellate court. But if you have a criminal trial with a defendant and it was used, I think, fugitive slave clause, abolitionists refused to enforce. And I think you mentioned that it was actually used in a terrible way back with lynching. They would let people who lynched black people, black children would get lynched, like Emmett Till, who they have a movie about his mother right now. But they would let them go. They would acquit them. And once you're acquitted in our system, double jeopardy, that's it. You don't get. The prosecution can never appeal. I don't know if we made that clear last time. Defense appeals. You get acquitted, it's over. So jury nullification is a jury disregarding the evidence and letting a criminal defendant go, is how I would describe it. I don't know. Does that make sense?
That makes sense, yeah. And because you're not allowed to ask what happens in the jury room, and there's no consequences for a jury not following the law, that's why jury nullification exists. But, you can't argue it to a jury. You would be disbarred, and and there's no jury instruction for that, and that's why he had this. Darrell Brooks had this long argument back and forth with the judge because he wanted the right to argue that, because he said jurors have a right to jury nullification, and they do have a right to do that, but you don't have a right to argue it because you're not entitled to it. And so that's why I said it's like Fight Club. You're not allowed to talk about it. It
I don't even know if
exists.
they have a right.
And if you're in a case, for instance,
You say
like
they have a right? Do you think that's correct? I don't
well,
know
if they can't do
can
anything
do
to
it.
you if you engage in it, then I mean, it seems like a right to me, right? Like if I am told to follow the law, but I don't, and there's no consequences, then I have a right to not follow it. And there's a couple of wrinkles to that, and I'll tell you one, and that's why I said if you ever want to serve on a jury, you should fast forward now, because if you're in a politically controversial case, like you're trying one of the 9/11 bombers, or in New Hampshire, for instance, a lot of people get prosecuted for growing marijuana, and jury nullification is a big thing there. The judge will ask, judge will ask oftentimes in voir dire when they're picking out potential jurors, have you ever heard of jury nullification? And if you say yes, they're going to kick you out. They don't want you on the jury because you know about it, and you're going to tell the other jurors about it. You're going to say, hey, it's wrong that this guy can't grow marijuana on his own land. I heard about this thing called jury nullification, and we should just let him go. So on a case that's controversial like that, if a judge asks you that, you won't be able to serve on the jury. They'll kick you out. And if you lie about it and they find out, they can prosecute you. So yeah, that's why I hope those of you that do want to serve on a jury one day, you did fast forward past this.
I think actually, and you brought up New Hampshire. New Hampshire passed a law in 2012 that would have allowed defense lawyers to argue for jury nullification, which was then nullified by the Supreme Court of New Hampshire. So that's I mean, we shouldn't get into it here, but judicial activism, quote unquote, is the definition of that is when a judge or an appellate panel, strikes a law. So that's nullification as well.
You know what? I just thought of a set of facts where jury nullification would go the other way. You said it's only for acquittal. I think it can go the other way. What if you're in some place? I don't want to pick on Texas, but I've been to Texas, and it's rural Texas, and it's a Mexican immigrant, and the facts don't support a conviction, but the jurors say, you know what, let's just convict him anyway, because the judge can overturn that.
Then you appeal it. You have a right to appeal it.
Right. So that would be, the juries are using nullification. They're not following the law.
They're attempting to nullify, but it can be fixed.
Okay.
I mean, you can have attempts at jury nullification in numerous circumstances, but the only way you can assure it, I mean, you can also you can have a court that doesn't fix it if it happens, but the only way you could be assured of doing it without any consequence for the defendant is, a criminal defendant where it can't be appealed. Yeah, I mean, it's just over.
Right. So yeah, on a conviction you can appeal it, and if you're acquitted, because of double jeopardy, you can't be tried twice for the same crime. So even if the jury completely disregarded the law and let you off because you're a sympathetic defendant, there's no appealing that. And I think, Brooks had a problem with that because he was not a sympathetic defendant. He ran over old people, he killed a kid, he dragged her to death. I
don't think the jury would have bought this argument for nullification.
Well, when he was, ranting and screaming at the judge and stuff like that and ripping his shirt off in court, like that doesn't seem like a person that you would go out of your way to let off. Like, so
ripping your shirt did a lot for Hulk Hogan.
But he wasn't on trial for anything.
He should have been. Right. For a few things.
Oh boy. We're gonna burn in hell for this. But let's take a short break because and then we'll come back, and then okay, we're back. And we did get some really great questions in the comments that I'd like to address with Dave. Some of them dealing with, for instance, disclosing a witness's prior convictions before they testify. And, we can also talk about the federal appeals and that famous case, Illinois versus Allen, which she was beating him over the head with. But some of the people asked about Nicholas Kirby, who it looks like had a prior conviction, according to online sources, for some sexual crime. And I looked it up. The picture looks like him, so it could be him. And apparently, this was when he was 20 years old, and the victim was either 14 or 15. So I don't know if this was like one of these college guys that date high school girls, or if it was something way more nefarious. I don't know. It's just he did have a sex conviction, and he's a registered sex offender. And this was in 2009, so 15 years ago. And there's several cases that talk about what the government has to turn over to defendants. And a lot of it is called Brady material, which is the famous case, Brady versus Maryland. And I think it's an interesting case to talk about. So Brady was a guy who was on trial for murder. He and another guy killed somebody. And because he wanted to avoid the death penalty, he didn't take the stand. And he had requested material regarding the other defendant, and the prosecutor gave them most of the material, but he didn't give them a confession that the other guy said that he was the shooter. And then this got appealed to the Supreme Court, and he ended up getting a new trial. So the interesting thing is, at the time, the law said that if the prosecutor intentionally withholds exculpatory information like this, you get a new trial. But if it wasn't intentional, no harm, no foul, even if you're in jail. But this obviously would have made a difference. And the Supreme Court said, like, no, you have to turn over exculpatory information or information that would reduce your sentence. And the fact that the other person was the shooter may have enabled him to get a lighter sentence or avoid the death penalty. So that's why that was there. Then later cases have said that you don't even have to ask for it. The government has to give it to you automatically. So the question becomes, well, what happens if they don't? And it wouldn't matter if it was intentional or unintentional. If you don't turn over all the information, what happens? And there was this other famous case, which is U.S. versus Bagley, where not Bagley. This was Giglio. You corrected me. I said it was Giglio because I pronounced it like
Giglio.
But you corrected me.
It's probably Italian, right? I think.
So U.S. and Chile was a really weird case.
There's an issue with the audio again.
Better?
Yeah.
I'll say. So it was somebody who was convicted of fraud because they were writing bad checks at a bank, and the teller was in on it. So teller in the old days would have something called a signature card, where if you write somebody a check, they compare your check to their check. And he gave this signature card of different people to this guy, Giglio, and the guy, Giglio, was writing bad checks. And they eventually traced it back and they prosecuted him. And the prosecutor did not disclose that the teller was given a sweetheart deal for testifying against Giglio. And then this went all the way to the Supreme Court because this technically isn't under Brady because it's not exculpatory evidence. He did commit the crime, but it's evidence to impeach the witness, the credibility of the witness. And the fact that the witness was given a lighter sentence doesn't mean that you were not guilty. It just means that they would have an incentive to lie. So Brady deals with exculpatory. This Giglio stuff deals with impeachment evidence for you to impeach the prosecution's witness. And then there was this Brady case. No, is it Brady or Bradley? I'll put it in the show notes because I forget what it was. Where somebody had been convicted and they didn't get some of this evidence that they were supposed to get. And this went all the way to the Supreme Court because in the Ninth Circuit, which is famous for being overturned a lot by the Supreme Court because it's very pro-defendant, they said, well, whenever we don't over this material, it's an automatic new trial. Like Oprah, you get a new trial, you get a new trial, you get a new
Audio problems.
All right. So the Supreme Court said, no, that's not a thing. You only get a new trial if it would have made a difference in the outcome. And in this case, I think it was Bradley or Bagley, they said it wouldn't have made a difference in the outcome because the witness who had been paid to testify against them, this guy had been charged with drug possession and gun possession. And he was testifying for the ATF on the gun possession, of which he was acquitted, but he was convicted of the drug stuff. And the court said, well, it wouldn't have made a difference because he wasn't paid for the drug testimony. He was only paid for the gun testimony. So it wouldn't have made a difference in the outcome. So those are the three major cases: uh, Brady, Bradley, and Giulio. And then there's, I think, what would apply here with this guy Nicholas Cruz, not Nicholas Kirby, if he did have a conviction and he wasn't told about it, the defendant. I don't think it would apply because there's also this weird outlier case called US v. Agers. And it's a really weird fact pattern. So a hooker goes into a motel. This sounds like a bad joke. A hooker goes into a motel with the John, and they check into a room, and the guy's got a giant on
Can't
his.
can't hear you again.
Okay, the guy's got a giant Bowie knife on his waist when he's checking in. The hooker saw it. The guy at the counter saw it. Everybody saw this knife. And it's like such a seedy motel that the bathroom wasn't in the room. It was like down the hall. So when the guy went down the hall, allegedly, the hooker started rifling through his stuff, and he came back. There was a struggle, and she stabbed him. So it turns out that this guy had prior convictions for violence, and they never disclosed this to the defense. And this Agers case said that this kind of stuff, if the defense asks for it, you have to turn it over. If they don't ask for it, you don't have to turn it over. So what distinguishes this kind of stuff from Giulio or Bradley is that the guy was dead. So it's not impeachment of a witness because he wasn't a witness. He was the victim and he was dead. And it wasn't exculpatory as the evidence.
The audio is coming in and out.
Okay. So she stabbed him, so it wasn't exculpatory. Self-defense is a defense that you have to affirmatively prove, but it's not. It's an affirmative defense. The crime is murder, and this is one of your defenses, but it's not exculpatory because you actually did it. So it wasn't under Brady. It wasn't Giulio because it's not to impeach the prosecution's witness. It's to malign the victim. It might have been helpful, but it didn't fall under those two. So the court said, you can ask for it and they have to give it to you. But if you don't ask for it, they don't have to give it to you. So I think with this guy, Nicholas Kirby, he was called by Darrell Brooks. So he was the defense. And if he had been a prosecution witness, then sure, they would have had to turn this over. But you turn this over because the defendant can't stop the prosecution's witness from testifying. So to keep it fair, you turn over this Giulio evidence and they get to impeach your witness using that evidence. But if it's your own witness and you don't like what is in their past, you don't have to put them on the stand. So I don't think there was a duty to release this info if they had it. But and if it gets in, there's also I don't know what is in Wisconsin, but in the federal rules of criminal procedure, there's a test that you use. How long ago was the conviction? If it was more than 10 years, you might not admit it. What kind of conviction was it? If it was a conviction for something relating to honesty, like, you were convicted of fraud, you were convicted of theft, it's more likely to come in because it would prove that you're a liar. So something like a sex offense like he did, or something like a bar fight or DUI, that probably wouldn't come in, especially if it was 10 years old. And, the closer it was in time, or if it involved a crime of fraud or moral turpitude or dishonesty, that's more likely that it would come in, but it would be a judgment call by the judge. How did I do? Is that okay?
Okay, but I think the lead is that this was Brooks's own witness. So
I buried the lead.
I mean, I don't know if you buried the lead, but I don't know if there's any authority saying that the prosecution has to hand over any type of impeachment evidence related to a defense witness for the reasons you brought up. It just wouldn't really make sense, although it is a good question. And if he was a prosecution witness, then it would fall under, which was it, Giulio. Giulio. But I think the other question was probably one that's going to be even more extensive as far as discussion, but the one about his being removed from the courtroom. Or did you have anything else you wanted to go on to say about the impeachment evidence relating to Kirby?
I think that's all I had to say, but I think the Illinois versus Allen thing, which is the case under which she cited to keep removing him from the court, I think that's an interesting one. And you were a federal appellate clerk, and that would be probably the best shot that he had to get a federal appeal, right?
Well, yeah, I think so. I mean, so here's the deal. Okay, in Illinois v. Allen, 1970 Supreme Court case, the U.S. Supreme Court says that at least under the Confrontation Clause and maybe some other aspects of the Sixth Amendment, a criminal defendant has a right to be at his or her trial. And so the Confrontation Clause is a clause that says you get to confront the witnesses against you, et cetera. And ultimately, what they said in this case is that you can lose this right if you're disruptive. If the judge warns you, and they said there are at least 3 constitutionally permissible ways to handle this. And that's important language too, because a court can, especially the Supreme Court, can lay it out and say there are 3 ways, and that could be the only 3 ways you'd have. But they say there are at least 3 ways, which lets you know that there are other possible ways that would pass constitutional muster. But they laid out 3 possibilities after you've warned the defendant to, simmer down. And the first, I think, was it to bound and gag the defendant if there's, as a last resort, you can bound and gag the defendant to keep the defendant in the courtroom. Number 2 was to cite the defendant for civil or criminal contempt. And the third one was to have the defendant leave the courtroom until the defendant promises to behave. And I just wanted to bring up, in number 1, the bounding and gagging, I think probably the most infamous, the most notorious case where that happened was when Judge Julius Hoffman had Bobby Seale bound and gagged in the trial of the original Chicago 8, which became the Chicago 7 after Bobby Seale had a mistrial, and I don't think he was ever even retried. But he was being disruptive, and Julius Hoffman had him bound and gagged, which was, this was the Chicago 8 trial was a result of the 1968 Democratic Convention, the unrest there. And Bobby Seale was a Black Panther, so just the optics behind having a Black defendant bound and gagged in this courtroom. And I think there have been, I don't know enough about this man's life story, but Judge Julius Hoffman, I think there have been suggestions that maybe he was a bit of a racist, but I am not certain of that. So that is something you'd probably want to avoid in most circumstances. So what happened here was, what was the judge's name again? I'm sorry, Judge.
Jennifer Garza.
Okay, well, she had him removed several times from really early in the proceedings, straight through sentencing, because he just wouldn't stop. And she did warn him. And I think one thing, and the possible issue he might really have, and this is what we were discussing, is in Illinois v. Allen, the Supreme Court they mentioned that standby counsel was there for Allen, and Allen was also pro se litigant. So it wasn't necessarily part of the holding, but they did mention that there was standby counsel there. And Darrell Brooks did not have standby counsel. He was brought to another room. He was given the audio and visual feed. And I think, was he allowed to type objections? He was given alternative means, and I don't have access to Westlaw or Lexis, so I don't want to say this with 100% certainty, but I could not find anything from any appellate court really on all fours with this, saying that this was acceptable or not acceptable, or when it is acceptable. And you'd want it to have, here, the situation is when you're pro se litigant, and Darrell Brooks, he waived his rights. He waived his right to have competent counsel. He waived all these rights. But there's a special circumstance when he's being removed from that courtroom. He still needs to have counsel, whether it's him or someone else. And he's acting as his own counsel. He's a pro se litigant. He's asked to type out these things, his objections, while he's listening to the trial, maybe hearing things, maybe not hearing things. He's not a sympathetic defendant. Obviously, these are federal issues that the Wisconsin State Supreme Court and the Wisconsin Appellate Court, the intermediate court, they are competent and they should deal with the federal issues. As my friend Martin made clear, there's almost no possibility that they would give him a new trial. They're not going to grant him a new trial. I don't even think the federal courts would, but I do think it's an interesting question as to whether this was acceptable and when it's acceptable. And I think it needs to be answered at some point as to what rights you maintain and how. I don't know if typing out objections. Maybe you knew more of the circumstances behind it, but it just didn't seem.
Here's my take on it.
And your audio is off again. So.
Okay, can you hear me now?
Yeah, I can.
Okay, so here's my take on it. I think there's a couple of issues, and we did mention that she went through this Ferretta inquiry where she asked him, about his education and do you understand how many years in jail you're facing? Do you understand that this is a complicated procedure? Do you understand that you'll be held to the same standard as a actual attorney? And a lot of times, he tried to avoid that, saying like, I don't understand, because maybe he thinks that he can argue it wasn't knowingly waived. But I think she took great pains to make sure that he was competent. And we talked in the last podcast about the insanity defense. Insanity isn't a clinical term. There's no medical book that you will see insanity. In the DSM-5 TR, which is the latest diagnostic and statistical manual for psychiatrists, insanity doesn't appear there, and neither does competence. So competence and insanity, those are legal terms. And competent to represent yourself doesn't mean you'll do a good job. It means, you understand where you are, you speak the English language, you can read these cases and understand what they say. Not that it's a good idea that you represent yourself. And in Illinois versus Allen, they did appoint standby counsel, and it was very similar to this. He was very, I think at one point he threatened to kill the judge, and he said, I'm going to keep interrupting. And it was the three options they gave them. One, you can hold them in contempt, right? So, you start with fining them or putting them behind bars. He's got no money. He's $40,000 back behind in child support, and he drives his mother's car. Money sanctions aren't gonna do anything. Put him behind bars. He's already behind bars. So that first option, not going to do anything. I think he wanted option 3, which is to be bound and gagged, because he wanted to argue jury nullification. I think it wasn't a good strategy, but I think that was his only shot. And so I think if she had bound and gagged him, that would have helped him. But she removed him to the other room, and he got upset by that because he actually read Illinois versus Allen, because he said, like, she gave him 4 options, and she said, oh, that's a 4th one. You're making that up. Illinois versus Allen only has 3, which is true. It does only have 3, but it was written in the 1970s before you would have this option to be in another room and be able to communicate via computer. And I think the big difference between Illinois versus Allen and here is, as you said, he didn't have standby counsel. And the case, the reason Illinois versus Allen went to Supreme Court is he was removed to the other room, and then the standby counsel kept going with the case without him. So in here, you can't have that because he has no standby counsel. And the Supreme Court has never said you're entitled to standby counsel or you're not. But the only circuit courts I've found that have talked about standby counsel said that you don't have a right to standby counsel. The judge can give you one if they want to, but you're not entitled to it.
In normal circumstances, though, these are different circumstances. I mean, every single one of those rulings was under normal circumstances when you're in the courtroom. I mean, well,
and there's a question also. I mean, there's no agreement about what standby counsel does. So I think in Illinois versus Allen, they had the standby counsel there, so they knew when this guy acted up, this other guy would take over and finish the case. But in other courts, they sort of see it as like phone a friend. Like, I have a question, I don't know how this works. And instead of him asking Judge Darrell, which she can't tell him, she said, I can't explain this to you because, I'm not your lawyer. You need to understand this and, look it up yourself. So in some courts, they sort of view this as, this guy's in the back, you can ask him questions if you want, sort of like phone a friend. And on other courts, they see this as sort of your standby. And then if this guy screws up so bad that he says, you know what, I changed my mind, I want an attorney, then that guy can take over. And there's a weird thing because it's a take back. It's not a do-over. So if you say, I want a lawyer now, that guy can take over, but any part of the trial that has already happened, like voir dire or questioning witnesses, you don't get to do that over. You know, you
Let
just,
me, if Peter, if you're a criminal defendant and you're going to have a lawyer, you want your lawyer sitting in another room on a computer watching this on TV on a closed circuit thing?
well,
Would you want that? Would you want
hopefully
that?
I would never get to that.
Oh, would you? Is that is it? Because we're not talking competence, we're talking conditions. Is that the condition you want a lawyer acting in? He's still acting as his own lawyer. I just don't know, and I'm not saying necessarily like it's not, permissible. I'm just wondering. I think it's a tougher question than, well, courts have said you don't have a right to stand by counsel. Absolutely, you're in the courtroom acting as a pro se litigant, as a pro se defendant, criminal defendant. You do not have a right to stand by counsel. You get removed from that courtroom into another courtroom, and this trial is proceeding. I don't.
Well, so he
like
did have this
I don't know if,
thing that he would
terrible.
hold up that said objection that they gave him, and then he would type what the objection was, which
Look what you're asking.
relevance or prejudicial or whatever else you want, hearsay, but without him having that colloquy back and forth, yelling with the judge, which wasn't really to convince the judge because he kept arguing the same things over and over. I think it was just to stall the trial.
Yeah, absolutely. But
yeah.
We still have
under those circumstances, you under Illinois versus Allen, you do waive your right to be in the courtroom. But as you said, in that case, they did have a standby counsel,
and
they said you should have a meaningful opportunity to communicate with your counsel. But they said on paper. So I think if he doesn't have a counsel and he's able to communicate with the computer or with his whatever.
I mean, I think you probably should try to get him to waive that right. Say, look, we're removing you from the courtroom. Do you want counsel? And get him to say no. He might say no.
So I think if he appeals on the federal after he loses his state appeals, I think that's probably the one. Not him. I think that's the one that his appointed counsel would hang his hat on. Is that Illinois versus Allen said you can do one of these three things, and Judge Darrow did this fourth thing. But as you said, it doesn't say when the client does this, the defendant does this, you can only do these three things. It says you can do one of these. You have at least these. It said at least these three options. So they're telling you there are more options, and you can think about what they are. But
did this go far enough? Is the question, I think.
And
it might have. It might have. I just think it's a more interesting question. He's actually, because I don't know if you were as dismissive as I was in the first one, but I was like, he's got no issues. But
I don't think he has any issues, and I think if he had one,
he has issues, but not legal issues. He's got a lot of issues.
This is his best shot, but I don't think it's a good shot because she on the record would say like, okay, you've interrupted at 2:02, at 2:08, at 2:09, at 2. That's 6 interruptions, and I'm removing you. So the Illinois versus Allen thing, it's a strange case, and maybe I'll put a link in the show notes, but they did mention that he was disruptive and he threatened to kill the judge, but they didn't mention how many times he was disruptive. And actually, one of the judges that I think dissented or did a concurrence, and those are terrible. I hate when they do a concurring opinion. But he said, the record isn't clear on this, so we shouldn't be ruling on this because we should only rule on cases where the record is clear. So, we know exactly what we're saying. But I think that was the issue. So she was making it clear on the record the number of times he was interrupting, what he was saying. For the record, he's taking his shirt off. For the record, he's staring at me. For the record, he's built a little box for it. Yeah. So when they do this trial transcript and, because he's got 20 days and then they type up everything that was said, that's all part of the record. So it's going to be harder for him to appeal her decisions. Because did we go over this? Like questions of fact almost never overturned on appeal because that's, the appellate court gives deference to the fact finder, whether that's a judge or a jury. On questions of law, they take a new look. But on these questions where you have the judge's discretion, like whether to remove a defendant or not, whether to admit prior convictions, when something is an exception to the hearsay rule, they basically, it's like the rule of reasonableness. They look at, would a reasonable fact finder have been able to do this? And then, yeah, that you're usually good. So,
And we should make it clear when they say a reasonable fact finder, in legal parlance, that means like an objective person. Could you reach that conclusion? You don't have to agree with it. You could disagree with the conclusion. That's why it's called abuse of discretion.
right.
It's like, oh, I'm looking at this. I think I would have let this in, but I understand where they're coming from. It's acceptable. So,
Yeah.
so it's like an intermediate standard between the de novo review of questions of law and like, just clear error on questions of fact. You'd almost never overturn a question of fact.
Yeah. So clear error, that's the first standard. And then the last one is abuse of discretion. I didn't know these words, but that sounds right to me.
I hope it's still right. I haven't used these words in a long time.
Yeah. So basically, if he had a shot in the federal system, I think that would be it, because in Illinois versus Allen, as you said, he did have a standby counsel. So if you have a standby counsel, why wouldn't you be bound and gagged? That somebody can take over the case for you. But if you're bound and gagged, you can't make objections, you can't confront the witnesses. So she didn't opt for that.
And bound and gagging is kind of prejudicial.
Right.
In
And
itself,
if he's removed
per se prejudicial, and I mean,
yeah. Well, and if he's removed to another room and then the standby counsel continues the case, fine. But he didn't have a standby counsel, so I think, she said, okay, it says at least 3 options. Here's a 4th option. I'm going to remove him, but he can still be his own counsel because he can waive this side.
She considered appointing standby counsel, which was interesting too. I mean, when she was talking about throwing him out of the courtroom, she brought up Illinois v. Allen and standby counsel, and I guess ultimately she decided that.
Well, he did have counsel at one point, and I think they entered an insanity plea for him, or insanity defense, and then when he withdrew, which is right before the trial started, it wasn't even the 11th hour, it's like 11 hour and 59 minutes. He withdrew his insanity defense, and his complaint was odd. He said, like, they're not explaining things to me, which that's not their job. They've got other clients they need to defend. Also, that they're not putting you through law school. They don't need to explain it to you. They just need to do a good job defending you. And he was saying they won't make the arguments I want them to make, which I think was this crazy sit stuff. The sovereign citizen, I don't consent. This indictment is in all capital letters, and that's not me. And as we said, as an officer of the court, you can't make those because you'll get disbarred for filing frivolous motions or things like that. So I think he wanted the freedom to be able to make those arguments that about sovereign citizen stuff or jury nullification, which you're not entitled to. And I think that's why he wanted to represent himself, which is always a terrible idea.
I mean, but certain admiration for he read Illinois v. Allen and kind of understood it, probably understood it better than some lawyers. So,
yeah. So, I mean, and that's wonderful for the state, because the fact that he said, there's 3 things there and you're coming up with this 4th thing. If he tries to say, like, I didn't knowingly waive my rights because I didn't understand what it entails, they can point to these cases where he actually had read them and come up with the correct argument.
Legal arguments here, sir.
Yes. It's a guy that doesn't know what he's talking about.
Volume. Audio.
All right. Yeah. So, I mean, competence, as I said, competence is not a medical standard. It's a legal standard, and it's a very low bar to get over that. I don't think it's an appealable issue.
I think we should also just say he's not getting out.
Right.
So, I mean, ultimately, we're going through these discussions. I don't know if they're academic or moot, but he's going to be spending the rest of his life in prison. You're not going to, certainly no state court's going to give this guy a new trial, and really no federal court's going to do so either.
I think so too. And I think the terrible thing about this trial, besides the number of people who died, a lot of people who've never seen a trial watch this, and they might get the impression that this is how trials normally go. But if he had an attorney, none of that screaming and constant none of that would happen.
You think anyone watched this thinking this is how trials go?
I hope not.
I don't know. Maybe some of the people who think I don't shower.
But yeah, I hope if God forbid somebody who's watching this gets in trouble, they don't think that this is a way to act in court because it's not going to help your case and it's not going to go your way. And if you thought about law school, um, this is not how a normal trial goes. This is a wild, wild ride, and I think that's why people tuned in. But I would hope that they would get other trials that they watch, which are more representative of what happens in the courtroom. Yeah. And not that I have any trial experience. As I said, I was a transactional guy. I did mergers and acquisitions, and now I do policy stuff. But this is interesting for me because I did go to law school. I find this stuff interesting, but it is more irritating for me to watch him act up and get treated with kid gloves than I think most people, because I do have a respect for the law because I do it for a living, and so I am more happy to see him go to jail than most of the people watching this video. So, but yeah, he won't get out, federal or state appeal. That's the too long didn't reach.
And just in case people are wondering, the appellate process is completely different from the trial process. He's not involved. He's not there. It's actually, when I was clerking, I mean, you just sit there. It's removed from the trial. You just have all the paper. You get all the records, and you're just reading everything. Yeah. You're not going to have any entertainment value or any type of televised coverage of the appellate proceedings. Maybe if there's an oral argument somewhere along the line, but otherwise, I mean, the tomfoolery is finished as far as his his 15 minutes of fame while he was
over. Yeah. And actually, most of the Supreme Court justices have no trial experience. Like, they were judges, they were appointed to the appellate and then to the Supreme Court. So they don't have actual trial experience. I think Sotomayor and Kentucky Jackson.
She's my favorite. You said Alito earlier, but I just want to make clear, Sotomayor is my true favorite.
Oh, I met her. She's a sweetheart.
She's awesome. She's awesome.
Yeah, she's really nice in person and very personable. She's a sweetheart. But I think the fact that most judges Supreme Court justices don't have actual trial experience, especially those that were around in the 70s like this, is why Illinois versus Allen reads the way it does, because it says, you can remove the defendant from the courtroom, and then if he promises to behave himself, you bring him back. And it doesn't say how many times you do that. Because she brought him back every other day. It's like, I'm kicking you out. I promise to behave, bring him back.
I was trying to find out how many times I could not figure out.
It didn't say, after 7 times or 8 times or 50 times, you don't have to listen to his promises.
The articles just said again. They didn't even give a number.
They said as soon as he, you can remove him, and then when he promises to behave himself, you can bring him back, because they've never tried an actual case. And so they think this is how a court.
They never ran into Darrell Brooks.
Exactly. Oh boy. So I think this is a really great discussion. So if anyone has any other questions, we try to answer the unanswered questions in this episode. But if you have any more questions, specific questions, put them below, and we'll try to answer the next one. Yeah. So I did try to. I promised I would try to get Dave to wear a shirt with sleeves. He didn't listen to me.
Never.
Yes.
But permanent attire now. After all those comments, this is it.
Well, you know what? One interesting thing. A lot of people said the guy in the wife beater interrupts too much, and you didn't interrupt me this time. I bet there's going to be a lot of comments like, "Oh, that guy with the glasses, he talks too much. Tell him to shut the fuck up."
Well, that's the whole thing. Whether they're good comments or bad comments, it's engagement. So
Yeah, they're going to say, you know what? I wanted to hear from the actual appellate lawyer, not the paper pusher who thinks he's a lawyer. So.
Oh God! And was this more liberal dribble?
Oh yeah, somebody posted a comment making fun of you that said like, I don't want to hear any more of your liberal.
It was both of us, actually. It wasn't
dribble. Okay, yeah, and then you corrected him, dribble.
Unless
well, I felt a little left out that most of the insults last time were to you, and I actually told you, you know what? Half of the insults that it's not clear who they go to, I'll take those, because I would like some of those. And I think there was one that called you said egghead is an ignoramus. I said, I don't know who that is. I'll take that one. And you said, oh,
That
that's
was
me because I'm bald.
totally me.
Like I didn't think of the bald thing.
That wasn't in this one. That was in the Bob Dylan one, which is really incredible
Yeah.
because I mean,
Yeah. Oh, episode we might have coming up. Dave wanted to do one on the WWE. He's a big wrestling fan, big Bob Dylan fan.
Vince McMahon,
Yeah,
Vince.
yeah. So there's
I'm on
some
Vince
corporate
next
law
week.
issues, and I used to be a corporate attorney, so he thought that would be an interesting discussion.
Vince
So if you'd
McMahon
like to
trying to
see that,
return,
yeah,
to WWE,
yeah,
getting sued based on allegations of sexual abuse from decades ago, from 1986, and one from a decade ago, which because there have been some state laws that have removed the statutes of limitations regarding sexual abuse. So I think it's pretty interesting. We'll see. But
yeah.
yeah,
And it's interesting because it's a publicly traded company, so we can talk about that because I used
yeah,
to
Vince
do
is trying to
that
get
type of
back
stuff.
after he's been removed.
Yeah. So this is a great discussion. Everyone like and comment. And if you have any other questions, put them below and we'll try to address them either in the
Positive,
comments or
negative comments.
yeah, there we go.
I shower. I do shower. Just want to make that clear again.
Yes. And we do have an imaginary sponsor, which is tap water.
Tap water.
If you're not
I
hydrated,
use when I shower.
There you go. You know what? I love water so much. I give this to my dog. It's the only thing she'll drink. So support our imaginary sponsor, tap water.
I drink water and whey protein shakes, which is made of water.
No promo code, anything. Just open the tap right there. All right, man. Great talking to you.
Great talking. Hope people like it.
Yeah.
Or don't like it, whatever. Listen.
Yeah, either way, let us know.
Either way.
If you have any ideas for future episodes, put it below. And we still don't know what to call this thing. So if you have an idea, put that.
Lawyers, one podcast. It's fine.
Yeah. 2 lawyers, 1 podcast. Oh, if you want to.
Questions are great.
Questions below. Yeah. If you want to email, I set up a fake email. Pete is not your lawyer @gmail.com. You can send me an email. And if it's for Dave, just put in the subject line, not for you, asshole, forward to Dave, and I'll send it to him. All right.
Awesome.
All right. Good talking to you, buddy.
Take care.
All right. Bye.
Bye-bye.